Welcome to Health or Consequences, the podcast devoted to healthcare and public health issues on the Codcast series. I'm here, Paul Hattis from the Lown Institute, with my colleague John McDonough from the T.H. Harvard School of Public Health. And we're recording about a little bit over a week since Steward Health Care filed for bankruptcy, and we think that's an issue that our podcast listening audience probably would like to understand a little bit better and learn more about. It just so happens we're in the week where our House is in the final throes of passing a healthcare bill over 100 pages long, and we thought it'd be wise to talk a little bit about what's in that. And we thought an ideal person to invite on to discuss both of those is Eric Gold. Eric's a lawyer and partner at Manatt Health, and he comes to that role having served over 10 years in the Attorney General's office, including as the chief of the healthcare division. Eric, just to jump into it, I thought that maybe you would say a little bit more about your background than that. And also, since we want to dive into bankruptcy issues, say a little bit about how in the healthcare space your life and experience has intersected with bankruptcy issues. So thank you and welcome.
Thanks so much, Paul and John. It's great to see you both, and thank you for inviting me to talk with you today. So, Paul, as you said, I'm a partner with the health group at Manatt Phelps and Phillips, sometimes called Manatt Health. I lead our Boston office, and I joined Manatt about 9 months ago after I left the Attorney General's office, having spent about 10 years there, the last 5 of which I led the healthcare division. I oversaw the consumer protections, civil investigations, as well as some litigation and our health policy work. And for better or worse, that meant, at least over the last several years, and some earlier, I spent a lot of time in and around bankruptcy court. I think my first experience with the Attorney General's office in bankruptcy court involved the liquidation and the closure of the North Adams Regional Hospital. And that was an unusual circumstance, which I know you both probably know well, and we worked on that matter. And then in more recent years, we had a Chapter 11 reorganization involving a healthcare sharing ministry, where the AG's office and other AG's offices were involved and working together. And we appeared in the bankruptcy court there to advocate for Massachusetts consumers. And really, most significantly, spent a lot of time working with other state attorney generals and lawyers from across the country in the pharmaceutical manufacturer bankruptcies involving the opioid cases. So those, in some ways, similar to Steward, were Chapter 11 proceedings with multi-billions of dollars at issue and many, many stakeholders and states and private organizations and from around the healthcare sphere, all sort of vying to have their interests heard. So I was able to represent the Commonwealth in those cases too, which I really enjoyed.
So Eric, thank you for joining us. This is John McDonough. Can you explain a little bit about the background of the bankruptcy court process, its main aims? In particular, Massachusetts is one of 8 states that have a stake in the Steward hospital sector. How does Massachusetts get its interests put before the bankruptcy court? And if the court does something the state doesn't like, can the state appeal it? Can you just give us a little bit of a walkthrough of how this actually plays out in the real world?
Sure. So at a high level, right, it's helpful to understand that a Chapter 11 bankruptcy, the purpose of it is to allow a company to reorganize its debts, right? Ultimately, it'll pay some, maybe reduce some, change some terms, maybe avoid some debts entirely. The language is a little helpful too. The company that files bankruptcy is called a debtor. It ultimately is going to propose what is referred to as a Chapter 11 plan for how it will be restructured. And the whole process is the debtor working together with the creditors and the other interested parties to try to get towards as close to consensus as possible on that plan, which would be proposed and then ultimately approved by the bankruptcy judge.
And can I just ask, is there a normal time frame that this takes? Or can this vary hugely? Could this go months? Would this go years? How long might this stretch out for a situation as complex as this? Do you have any idea?
Yeah, so it's quite varied. Chapter 11 proceedings based on the size of the case and the complexity. As you said, this one is in some ways quite complex. There's billions of dollars at stake, 30 hospitals across multiple states, many different lenders. On the other hand, Steward and its lenders and its landlord have all said they want to move quickly, at least on the key issues in terms of the proposed sale of the hospitals and the physician group. So if their predictions are true, then that will happen more quickly in a matter of months. In terms of resolving the entire case, that is getting a plan that is approved and blessed by the court, that'll take many months, to years is likely the course of time.
And is this process open to the public? Is it out in the open? Do people know what's going on, or is it in secret until the end of the process?
It's quite transparent. So like any court proceeding, the court filings are available. Actually, bankruptcy court filings compared to some other courts are even more available. There's a public website where anyone can go and read any document that's been filed with the court. The court's proceedings themselves are open to the public, either in person in the bankruptcy court in Houston, or more frequently these days over Zoom or another teleconference or video conference platform. Of course, there are lots of conversations happening on the side and negotiations between and among the lawyers that are not all going to be public, but there are regular court proceedings where the lawyers will come before the judge and in public report what's happening. So folks who are interested can follow the case on the website that is available through the court and through the steward's agent that it's hired to sort of organize these things, and then listen into the court hearings if they want.
At some level, the bankruptcy court has to concern itself with the people owed money, the creditors of Steward. At the same time, in order to sell things so that the creditors can get money, states like ours, have operative laws tied to review of market transactions connected to sales, or we have worries about adequate access of hospitals remaining open and capacity and employment concerns. How is all of that weighed in bankruptcy court?
All good questions, Paul. I think what's really interesting and important to know here for those who listened to the first day's court hearing, which was almost a 3-hour hearing, you heard Steward's lawyers and the judge and really all the lawyers, including for the lenders and others, say again and again that they are going to work really hard to avoid any disruption to hospital services. That was clear from the beginning with getting the court's approval to pay salaries for the doctors and nurses and other hospital staff. And even Steward's lawyer, again, saying over and over again that it's going to work to keep the hospitals open. One particular thing to note that the bankruptcy code requires, although with some exceptions, that the court, in cases where a hospital has filed bankruptcy, appoint what's called a patient care ombudsman. And this ombudsman is responsible for, as you might expect, sort of overseeing the patient safety and quality at the healthcare facilities of the company that's filed, and then make reports back to the court about that. So that's all a piece of it. That does all come with the caveat, as you suggest, that ultimately the point of the bankruptcy process is to restructure the company's financial affairs, right? So there will be lots of talk and discussion and briefs filed with the court about who is owed how much money, which of the lenders is in front of the other. It could also mean that as part of the process, as Steward has said, is that it's going to attempt to sell its hospitals, and that if the circumstance that makes the most financial sense involves the closure of one of those hospitals, that's something that could happen. But again, as I said, and as all of the lawyers said at the first hearing last week, the goal is to keep those hospitals open. So we'll have to wait and see whether there are bidders for the hospitals, and if so, if those bids are acceptable to Steward and its landlord and others.
Eric, let me follow that up a bit, because it's been announced, I think, by Steward and perhaps the court as well, the intention to maybe sell those hospitals by the end of June, assuming that you can identify buyers for some or all of them. But as you know, in Massachusetts, we have regulatory processes that oversee sales and license transfer, involves HPC and DPH and possibly even the Office of the Attorney General. How do those agencies' review factor into the court's decisions or the timing around a particular sale?
So interestingly here as well, the steward's lawyers addressed this in the first hearing, and they indicated that they intend to go through the regular state regulatory process for review of hospital transactions. And that's one of the reasons why you may have seen reported that stewards expressed some skepticism that they can meet this very accelerated schedule that their lenders and others have required. So, if there's a buyer that's acceptable to Steward and to the other parties with financial interest, you can imagine there might be some pressure on the Commonwealth and the Department of Public Health and others to review that transaction quite quickly, especially if it's not one that raises antitrust concerns. You could imagine a new buyer or an out-of-state buyer or something, but there's still a regulatory process there. But again, it's really going to entail negotiation among the parties. Steward is, I think, a good metaphor is really sort of the MC of this process, right? But the lenders especially have a lot of sway. So, if Steward says and the lenders are demanding, a sale of a certain hospital by July 1st, and the Commonwealth or any other regulatory agency says we need another 30 or 60 or 90 days to review or more, it's really going to be them negotiating together and ultimately a judge deciding, how much time is enough to review before objections are heard and it's decided whether the sale can be approved.
Now, Steward owes a lot of money to all sorts of people, including physician groups in our state. How are their interests represented in bankruptcy regarding payments owed to them? And will they get paid likely or not?
Yeah, so anyone who's owed money by Steward or by any company that files bankruptcy is, as you say, a creditor. And they can, on their own or with others, hire a lawyer and appear in the bankruptcy court to argue their case. As I said, all the filings are online, so they can review them. They can request to speak in court as well. They're also represented through something what's called a creditors committee, and every Chapter 11 case has this. And the U.S. trustee, which is the U.S. Department of Justice representative in a Chapter 11 process, will appoint a creditors committee, and then will appoint a lawyer or law firm to represent that committee. And that committee represents all of the interests of all of the unsecured creditors. That's everyone who does not have collateral for their security interest for money that they're owed, which would include most of the folks that you're talking about. So, and ultimately, in this case and others, there will be a process for creditors to submit claims, which means you literally write down on a claim form the amount of money you think you are owed and submit it to the bankruptcy court. And the court then evaluates all of those claims and determines who gets paid based on the priority rules in the bankruptcy.
So this is John again. Thank you again, Eric. So before the bankruptcy became official, the bankruptcy filing, Steward announced a potential sale of its national physicians network to Optum, which is owned by United Health Care. And of course, Massachusetts is one of 8 states in this situation. Does any particular sale or disposition of the physicians network have to be a one-size-fits-all? Could Massachusetts, for example, say, well, the rest of the country might go to United, but we don't want to see the network of physicians in Massachusetts go to United? Is that feasible? Is that within the flexibilities of the state and the court? How might that play out if it's based on a policy concern about market consolidation, for example?
Right. So just to step back a second and remind the audience, what Steward has said now is it's effectively going to auction its physician group, this so-called Stewardship Health entity, right? And it's described to the court that it's going to use the Optum offer, which, by the way, is not public, at least as far as I can tell, in terms of how much they're offering to pay or what the specific terms are, but use that as what is called a stalking horse bid. And that means that the offer from Optum would set a floor price and that other bidders would be invited to outbid Optum. So with the stalking horse, you can imagine that other bidders could come in and just bid for the same thing Optum, assuming they offered for the whole group nationally, or they could bid for a piece of it, together. You can imagine 3 or 4 bidders coming together and bidding for pieces of it together. But ultimately, it will be up to Steward and its other financial backers to determine which of the bids it thinks is best and propose accepting those bids to the court. And then the court will make those assessments. And you can imagine objections from bidders who were not selected or from states or others who didn't think that that was the right thing to do.
So let's just follow up on that. Let's say there's a group that would like to buy one or several of Steward's Massachusetts hospitals, and for whatever reason, the state does not consider them to be in the interest of the public to take over these institutions and refuses through the Department of Public Health to give a license to the newly owned entity, to the change of ownership. Can that block what's going on in the court, or does the court trump the state regulatory rules and laws?
Yeah, so a lot of these specific questions, I think, are subject to legal debate for sure. In terms of the hospital licensure point, Steward has said that it intends to move through the licensure process. The specific question of, if push comes to shove, if there is a buyer that's been identified by Steward or by any debtor, and it goes before the bankruptcy court, and a state or other law enforcement agency believes that such a sale would be illegal, would be anti-competitive, ultimately they would have to try to do what its state would have to do anywhere to block a transaction. That's file a lawsuit to try to block it. And then it really goes before the judge. So that would be sort of a quite unusual circumstance. Even outside of bankruptcy, it doesn't happen a lot where law enforcement try to sue to block a transaction, but it seems even more unusual in a bankruptcy. But Steward has said it's going to sort of comply with the regulatory requirements, and if it's not an anti-competitive thing, if it's just can they satisfy the requirements to get a license? I expect those regulatory processes to move forward.
Let's just do a hypothetical. Let's say another private equity hospital firm wants to come into the state. I think there's right now a lot of indignation across government and across the state at the impact of private equity in the healthcare system. Could the state refuse to grant a license to the new ownership? Do they have that right? And then what would happen inside the bankruptcy process?
Yeah, I mean, so that at the basic level, a question of state law, and I'm not sure the ownership, at least as the way the law stands today, whether the department has the ability to decline to issue a license to a hospital based on the for-profit status of the owner. But if an owner fails to satisfy, I think, any of the requirements, if they don't have the right credentials or they haven't satisfied the filing mechanisms, I expect that the state would not issue a license. But I'm not aware of precedent or cases where a bankruptcy court or any court has forced, for instance, a state to issue a license to a particular agency. But I think the state has to be complying with its laws, and if it's not complying with its laws, there might be concern brought on that.
In your mind, Eric, were there any big missed opportunities by the state to try to avoid getting into the current situation we're in right now, where such a large part of our system is so much at risk and in jeopardy? Did the state have some opportunities that perhaps folks let slide?
So it's hard to know for sure, John, and acknowledge I was in state government for a lot of this. But it's I guess important to remember, right, that the Caritas hospitals were struggling financially when Steward bought them in 2010. Right, Steward's business choices since then, their rapid expansion, the sale and leaseback of the facilities, the significant dividends that it paid to its ownership, all meant that it was taking on more and more debt. And that it was really, and then of course, when the finances of running a hospital system changed after COVID, it's been impossible for them to get themselves out of debt. So in some ways, the financial concerns and troubles for this hospital system are not new. In other ways, it was not easily predicted. I think sort of moving forward, I mean, what the state is going to try to do is keep as many of the hospitals operating as they can. Again, I think both Steward and the Medical Properties Trust that owns the buildings says they want to do that. So hopefully there'll be other operators, hospitals that can and are able to take them on. And, on the regulatory side, the Health Policy Commission, the Attorney General, and other federal agencies will continue to review the proposed sales of both the physician group and any of the hospitals. And if they believe there's something anti-competitive, they'll make that known. It's also worth noting that the Attorney General has said, and I think I saw her on social media again this weekend, that her team is looking back and reviewing closely Steward's business practices. And if there's anything that they think was unlawful, they're going to do something about it. And it's worth noting too that that's not unprecedented, right? The AG's office in 2019 brought a case against the private equity owners of a mental health clinic for when that was involved in Medicaid fraud. So if they think there was a legal violation, they can take that on.
Eric, thank you for all that great information. Let's pivot away from Steward and talk a little bit about what's happening in the legislature. The House and the Senate are moving toward already approving or getting ready to approve legislation to address or respond to the Steward situation and to try to create some greater accountability and sense of planning in the healthcare system in terms of the needs across the state. Do you have any reactions or thoughts to anything that's in the recently approved House legislation that you might want to comment on?
Yeah, well, thanks, John. I think at the risk of declining your invitation to pivot away from Steward, actually, the first two provisions that caught my eye, having reviewed the bill, I think are things that seem to have been directly inspired by Steward. And I understand the draft is being amended as we speak, but there are two specifically. One that seems to require that any company that's going to repossess a hospital's medical equipment or medical devices has to give notice to the Department of Public Health. My guess is that's a response to the news reports about the situation at one of the Steward hospitals where someone, a patient, lost their life because medical equipment was not available. And that would be, I think, quite new and interesting to know if that sort of requirement would ever come into play. But that was interesting. And the second was a provision related to the relationship between hospital operators and licensees and the land on which they sit. And I think this has gone over, there's been some recent amendments. One may have prohibited or required hospitals to own the land themselves. I think the newest version I saw today prohibited hospitals from renting from a real estate trust. But in any event, it's an attempt to sort of get at this, what some view as a concern around Steward's finances related to its sale and leaseback of its facilities. I think what's notable is that there's been a lot of attention and discussion about big policy changes related to private equity in healthcare and hospitals. And what's proposed, at least in the bill, as I saw it this morning, are two pretty specific things. The other thing that caught my eye, just as a former state government healthcare guy, is the proposal to create a new office of a health insurance commissioner. This certainly takes up a lot of pages in the draft bill as they find and replace health, insurance commissioner with health insurance commissioner every time. But it'd be interesting. I don't know how the various payers and providers and others would respond to this. I know there's been, again, talk for a while, and I know personally that the insurance commissioner's staff, especially in the Bureau of Managed Health Care, has a lot of responsibilities on their plate, and they do a lot with not a lot of resources and a thin staff. And whether this kind of restructuring of the state agencies would give them the additional resources that would allow them to be more effective in doing their work. It was interesting also for me to note that the proposal did not involve moving that new agency under the Executive Office of Health and Human Services, where you think it might sit, but would leave it within Housing and Economic Development. So anyway, two maybe smallish things, but were interesting from where I sit.
Eric, but my overarching question about the bill, and perhaps the House inspired by wanting to deal with what's happened with Steward, perhaps in part also wanting better oversight of a variety of different kinds of market transactions. There seems to be different provisions, dedicated to strengthening the role of government agencies, the Attorney General in some places, HPC in part. Any overarching reactions that you have when you look at some of those aspects of the House proposal?
Sure, and I mean, my focus is obviously on the Attorney General's office because that's what I know. And I think one provision that's pretty significant that might escape notice from some is how some of the language talked about, and again, this might still be in development, but it's talked about the effect of a referral from the Health Policy Commission to the Attorney General following a cost and market impact review. So under current law, basically, if the HPC makes certain findings related to the material change and makes a referral to the Attorney General's office, those findings in that referral, including HPC's report, are allowed to be evidence that the Attorney General can use in court if they seek to challenge the merger, and are so-called prima facie evidence of a violation of the law. What's unusual is that hasn't been tested, of course, since the 2012, since Chapter 224, and so in prima facie is there's not a lot of legal precedent for what that means in that context.
Just to understand that for our listeners, that means that if the HPC makes a referral with certain kinds of specific findings, the AG can go into court and say, HPC has found these things, therefore we think this transaction should be blocked. And is it like a rebuttable presumption where then the moving party has to then show evidence why the HPC might have been incorrect? Is as strong as that, or is it not quite what I'm describing?
No, well, so you've gotten to the issue, Paul. So the old language was prima facie, and it's not clear. I think there's legal debate as to whether that is a rebuttable presumption. The language I saw in the new bill this morning would change this and be explicit that this is a rebuttable presumption, which would give more leverage, if you will, to the Attorney General's office, I think, because this is sort of an accepted legal concept. And the idea would be if the Attorney General is suing to block the transaction, they would now be able to rely quite heavily on the report from the HPC. Whereas historically, at least over the last decade, they've had this language, but it's been uncertain how a court would treat that, whether the AG's office would still have to prove up the entire case that this was, an unlawful transaction, or they could rely heavily on the HPC's findings. And it seems that the House bill would increase the significance of that, give more significance to the Health Policy Commission's findings, which in turn would give more leverage to the Attorney General.
So, Eric, you've spent a lot of time with John and I talking both about legal issues in bankruptcy and health policy and the House bill. We so appreciate you taking the time today to chat with us about it. I'm sure our audience will find what you offered quite thoughtful and quite interesting as they think about all these issues going forward. So thanks again for joining us today.
Well, you're certainly welcome, and thank you for having me. I look forward to listening to your podcast, as always.